Ms. Turpin was sentenced by this court on August the 30th of 2024 for a computer crime, a level 8 felony, with a controlling sentence of 9 months Department of Corrections, 12 months post-release, 18 months community corrections probation. As a condition of probation, she was ordered to serve 60 days in the county jail as a condition of probation. A warrant to show cause alleging probation violation was filed by Mr. Cutley on behalf of the Community Corrections Department, alleging that the defendant failed to report as directed. And apparently on January 8, she was directed to remain on the property of Sedgwick County Community Corrections until a urine sample was submitted. From that language, it's unclear what the violation was. I trust, Mr. Cutley, you're alleging she didn't stay on the premises or give the sample?
Yes, Your Honor.
Okay. Then the third allegation is that Ms. Turpin failed to attend substance abuse treatment as directed. What are your client's intentions regarding these allegations, Mr. Watts?
Your Honor, I discussed the matter with my client. It is my understanding my client would agree that she failed to report in February of 2025 and it failed to serve that 48-hour sanction, that she would waive hearing on that matter. She would likewise agree that she failed to remain on the property of Sedgwick County Corrections until a urine sample was submitted in January of this year. And likewise, she would acknowledge that she failed to attend a substance abuse treatment as directed. I would note that she has now entering that Miracles treatment program. In fact, I had sent an email to yourself and Ms. Norris with the documentation of that. She is now entering that Miracles program. In fact, when I spoke with Ms. Turpin, it was yesterday, she was speaking from that Miracles program. She really wanted to do this hearing from her treatment provider. However, I know Your Honor is very insistent about doing that from the courthouse, and that is where she's at.
All right, Ms. Turpin, your attorney has made an announcement on your behalf that you now intend to waive any formal due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, present your own evidence at a hearing, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
Is it your intention to waive a hearing in this case and stipulate and agree that you committed the violations as alleged in the warrant to show cause?
Yes, Your Honor.
Very well. Court finds that the defendant has knowingly waived her right to a hearing and stipulates and agrees that she committed the violations as alleged by Mr. Ketley in the warrant to show cause, failing to report, failing to give a urine sample as demanded, and failed to attend substance abuse treatment as directed. We'll now turn to disposition in this matter. Ms. Norris, what are your office's recommendations?
Your Honor, this is defendant's first warrant to show cause in this case. The court placed her on 18 months community corrections probation at the end of August of last year. So it would appear that she has almost 7 months of probation left. So I'll leave it to court's discretion on whether or not the court wants to do an extension or just have her continue on with community corrections with all previously ordered and standard conditions to include the drug alcohol treatment and payment of fees, etc. And Your Honor, state would be requesting 2 days in the county jail as a sanction for the issues that she has had thus far on probation, and the court will need to address additional attorney's fees in the bids application fee.
Mr. Ketley, do you have any other remarks or recommendations to make to the court regarding this defendant and her probation?
No, other than she's the one that set up her own inpatient treatment, so it looks like she's trying to do what she's supposed to be doing, Your Honor.
As far as the prosecutor's comments regarding whether this case should be extended or not, do you have a view on that, Mr. Ketley?
I believe if it gets to the point when we get close to February, if she needs to extend it, we can extend her at that time, I think. Hopefully she'll be done by then.
Mr. Watts, your recommendations regarding an appropriate disposition for Ms. Turpin.
Your Honor, we join the recommendation of the state as to the due date sanction to begin immediately. I'm with Mr. Ketley. I would think that the condition is whether or not it needs to be extended is something we can take up when we reach that time. If Ms. Turpin is diligent in getting her things done, that may not be necessary.
The court will address Tricia Turpin at this time, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Turpin?
Yes, Your Honor. Like they said, I am currently in inpatient treatment at Miracles. And I just got out of jail on the 1st of July, and I had served, I believe, from the like 10 or 12 days of in you guys' jail, and I would ask that be counted as time served, so I may return to my inpatient treatment and continue on with my treatment.
All right. Anything else, Ms. Turpin?
That's it, Your Honor.
Ms. Turpin, I'm just going to make some observations here. Observation number one, it does appear that you need treatment. You apparently recognize that. You've entered into the Miracles program, but you've been on probation and out of jail since about November of last year. You didn't enter voluntarily treatment in November, December, January, February, March, April, May, or June. Only after you were facing revocation did you enter yourself into the Miracles program in early July. And I understand that you may have been incarcerated on this warrant for a short period of time, but you made bond. And then all of a sudden, apparently, you had an epiphany and you decided that after all this time and after all the urging done by your community corrections officer, you were finally going to take treatment seriously. Now, I don't know if your drug problem is so profound that you need a detoxification, which is usually a primary goal of inpatient treatment, but it also is somewhat confining. And perhaps that's the type of treatment program you need, because apparently outpatient doesn't work because you just don't go. So I'm wondering what's different now that this court would have any reason to believe that you're going to be successful on your probation. The second observation that I want to make, Ms. Turpin, is that you received a very harsh sentence at the beginning of this case. In fact, you got the most jail time that this court was legally authorized to impose as the start of your probation, 60 days. And you were quite emotional when the court sent you to jail. In fact, you did some, which I would just describe as wailing, to try to get this court to change its order, which the court did not do. And you served out your 60 days. And I would have thought that after that experience, Ms. Turpin, you would never take a chance of ever coming back before this court on a probation violation. But I'm disappointed that you're here, because I thought that at that point you would take your property crime probation seriously. Whatever your officer asked you to do, you would do your best to do and not mess up in the way that's apparent before this court. You don't just get to decide that, well, I'm just not going to go to that treatment program. I'll find my own. I'll enter it. But there's one thing that's in your favor, Ms. Turpin. When I saw this letter from your attorney today, I thought that you were going to try to use this inpatient treatment program to get out of coming to court, that you were ordered to do by Judge Crum. And the way Judge Crum knows that this court wants done, and that is you appear at the Judicial Center. You did show up, Ms. Turpin. That's a plus, because the court would not have allowed you to use remote proceedings from the treatment facility. Mr. Watts is quite correct on that, because he has considerable experience in this court. I want you at the courthouse, at the Judicial Center, at that location to face the music. And to your credit, Ms. Turpin, you did. quite frankly, Ms. Turpin, this court's analysis, as everyone argued, was why should I order a short-term jail sanction when the long-term jail sanction didn't work?
Hmm.
Do you have anything to say about that? 60 didn't work. Now I can order another 60. And maybe the second time you had a serious sanction, maybe it would make an impression on you that the first time didn't. But they're recommending a 2-day dip sanction. And quite frankly, is that going to make any impression on you whatsoever?
Yes, Your Honor.
Okay, why are things different now?
I've decided that the way I was living my life was inappropriate and not good for my health. And I'm very sorry for my actions. And obviously, I'm not getting no younger. And it's time to straighten up and do something different
Okay, different from what?
from the way my past, like you say, not handling what I need to take care of and not following the rules of my probation, and not just the rules of probation, just the way of that kind of lifestyle, the drug habitat, all that kind of lifestyle that's not appropriate.
Well, including stealing from others. Would you agree?
Exactly. And stealing from any kind of harm towards anybody in any kind of way,
Hmm.
including myself.
I'm also always disturbed when apparently there was some arrangement with your officer that you were going to do a 2-day dip sanction and you didn't show up for it.
I was
Explain that to me.
very scared that I wasn't gonna, again, I was high on drugs and I was very scared that I wasn't gonna get released after 48 hours, which is no excuse.
No, it isn't.
Um, I I made the mistake of not reporting like he asked me to, and that's my fault, and I'm very sorry. And there's really no logical explanation I can give you as to why I didn't show up. All I can do is show you that I can do better, that I am better, and that you won't have no more trouble out of me. And I can only, from this day forward, I can only show you that I'm not going to be back in your courtroom, that I have learned something from what you guys have from the very beginning to now, instead of making all these mistakes and keep coming back in front of you. I mean, like I said, again, I apologize for my mistakes, and all I can do is show you that I can do better, that I am better.
All right, Mr. Ketley, if I could address you.
Yes, Your Honor.
Mr. Ketley, obviously the record reflects that you attempted to do your own graduated sanction, in other words, a 2-day dip sanction, but she has not completed any type of dip sanction to this point.
That's correct.
All right. Ms. Turpin, when an officer tries to give you a break and gives you a 2-day dip sanction instead of taking further action, and then you blow that off, the court considers that serious. The court's not inclined to just reinstate the 2 days. The court will impose a 3-day dip sanction as part of Kansas's graduated the sanction scheme. But Ms. Turpin, you're running out of chances. And this is a prospective sanction, Ms. Turpin. And I hope that the treatment program that you've entered, Miracles, which has had success with some other people that have come through my court, I hope you can have the same success with them. I hope they'll take you back after you serve the next 72 hours in the county jail. While you receive credit against your overall sentence for time previously served, the court will not give you credit for time against this prospective sanction. So you do have, I will order you into the county jail to serve 72 more consecutive hours, then be released back into the community on community corrections without extension. At this point, you're to satisfy any condition that has not yet been satisfied. Furthermore, this court will require, as a condition of your reinstatement, that you complete the program that you chose, Ms. Turpin. I'm going to presuppose Miracles will take you back, and that you are required by this court to successfully complete that program because you chose it. You recognize that that was the program for you. There's no reason that you shouldn't be successful in it. So that becomes an additional condition of probation for you to meet. And then if they make aftercare recommendations, you're going to need to complete those.
Yes,
So
Your
I'm
Honor.
sure they'll provide appropriate documentation to your community corrections officer as to what they recommend upon discharge if you'll just sign the appropriate releases. Okay?
Yeah, and Teresa says.
All right. Ms. Turpin, again, I hope that this is the last time we have to go around on this. That you really do see that it's just better just to complete your requirements and get this behind you. The court will be waiving additional bids assessment in light of the court's incarceration order and her current placement in inpatient treatment. Finding additional bids amounts would be futile at this point. Anything previously imposed obviously remains to be paid. All right, Ms. Norris, is there anything else from your perspective that the court still needs to address?
No, Your Honor, thank you.
Any questions from you, Mr. Ketley?
No, Your Honor.
Mr. Watts, anything further from defense counsel perspective that the court needs to address here?
No, Your Honor.
All right, and finally, last but not least, Ms. Turpin, do you have any questions for the court regarding the court's orders made today?
No, Your Honor.
Okay. Well, I hope that they'll let you use a phone to call Miracles and let them know what happened and that you intend to immediately report back to the program upon your release 3 days from now.
Thank
Okay.
you.
All right. The court remands her into the custody of the Butler County Sheriff's Office for her to be transferred to the jail to serve 72 hours in the county jail as a condition of reinstatement of her probation.
So what?
Right. If there's nothing further, then the Patricia Ann Turpin matter will currently be in recess.